Hi, good morning.
Good morning, Ms. Dixon. Ma'am, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one.
Yes, Your Honor. On February 24th, 2024, at approximately 11:27 a.m., the officer did a license plate check on a vehicle that was shown to be registered to have active Class B warrants out of Montgomery County for driving while license invalid, and 6 Class C warrants from Humboldt Police Department. The registered owner was shown to be a black female, and that female was seen driving the vehicle through the lower driver's side window, giving the officer reason to believe that the registered owner was currently driving that vehicle at the time. A traffic stop was initiated. The officer made contact with the defendant, who was identified by her Texas driver's license. The officer ran the defendant's information and showed that her license was ineligible and that she did not have any confirmed insurance. The Montgomery County Sheriff's Office and Humboldt PD confirmed the warrants.
Okay, can you run her license down?
Yes, Your Honor. It is not eligible right now.
Ms. Dixon, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to drive. I do not care what's going on in your life. If you do not have a Texas driver license and liability insurance in your name, you are not allowed to drive. If I find that you do, I will revoke your bond, put you in jail. Do you understand?
I have one question.
Stop. This is not the time for that. If you need, I can provide you a lawyer today, but this isn't where you just get to start asking questions. It's number one. Number two, this is a court. When you come to court, please dress appropriately, okay? So I'll have you go fill out an application with Miranda. I'm gonna have you sign a receipt with Victoria. I'll have you take your seat in the jury box while we get your bond conditions, and then we'll have you speak to the lawyer here in the jail. Please. Mr. Lumumba, you are charged with 2 counts of driving while intoxicated. You've worked out an agreement. They're going to dismiss one in exchange for your plea on the other one. Pleading on 089. This one is, they're all both 08. The agreement that you have is 180 days in jail to be probated for 15 months. As part of the agreement, you will do a DWI education class. You will do 3 victim impact panels. Substance abuse treatment. You will also do what's called a TRAS. The TRAS is an evaluation to see what other conditions you may need. They will probably, because the fact that you have 2 open DWIs, they will probably add other conditions. It may be supportive outpatient treatment. It may be intensive outpatient treatment. I don't know. It may be inpatient. I have no idea. You must fulfill whatever other conditions they assess on you. No drugs, no alcohol, a guardian interlock, 25 hours of community service. Is this how you understand the agreement?
Yes, sir.
You need to understand that one of these will go on your record. The other one is going to be dismissed. But because of the fact that you have at least one of these going on your record, officers will always see this forever. It doesn't matter where you are, whether you're here, whether you're in Maryland, whether you're Alaska. And if you get pulled over, an officer, first thing they do is they run your license. They're going to see DWI. If they come up to your car and they smell alcohol on you, what do you think they're going to do?
Pull me out.
Not just pull you out.
And breathalyze.
And what?
Arrest me.
Probably. I don't know for sure. But chances are they're going to see DWI. If they come up to you, they smell alcohol, it's probably not going to go well for you. So if I were you, even if you've had a sip of alcohol, don't get into a car because you're playing Russian roulette with your life. Do you understand?
Yes, Judge.
You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, you are done with this forever. You can never change this. Do you understand?
Yes.
This is what you want to do. How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will send it to the agreement. I'm not going to suspend your license because you're taking the probation today. I don't know what DPS is going to do. They may suspend it, they may not. So Do you know if his license is eligible now?
So Your Honor, it looks like he has a New Hampshire license, driver's license, but it does appear to be eligible out of New Hampshire.
Which one?
A New Hampshire.
Anyway, so if your license is not valid at this point, you are not allowed to drive. You need to get permission from us. You're going to be signing an affidavit with us today promising us you're not going to drive. Do you understand?
Yes. You said it was?
It is eligible.
It is.
Oh, it is eligible.
Yes, Your Honor, it's eligible. It's an eligible New Hampshire driver's license.
Okay, as long as you have a valid license and you have liability insurance. So you must have car insurance. If you don't have car insurance, you're not allowed to drive. Do you understand? The other thing that you need is that if you're going to drive in whatever car you drive, you must have an interlock in it. Do you understand?
Yes, Judge.
So if I find that you don't have an interlock, it goes in lockout because you failed to pay for it, I'm going to issue a warrant for your arrest. If you don't remain in compliance with this, like you don't do your stuff on time, I'm going to issue a warrant for your arrest. If you're living in Maryland and I have to issue a warrant for your arrest and they pick you up in Maryland, holy moly, you're going to sit in jail for a very long time. So if you ever have any problems, you need to get in contact with Will. You need to get in contact with the Shatoria, because if not, and it goes into warrant status and you get picked up on it, you're going to be sitting for a long time. Do you understand?
Yes,
It
Judge.
takes forever in a day to extradite someone from another state to here. I mean, we're talking weeks. Do you understand? I'm not asking much. All I want my street safe. That's it. All right, how do you plead to the DWI? Guilty or not guilty?
Guilty.
I'm going to find you guilty. Like I said, I'll follow the agreement. Your other case will be dismissed. Good luck to you, sir.
Thank you.
Are you working now? What are you doing with yourself?
I found about a main,
Okay.
and yeah,
You're working currently.
yeah, it's yeah.
Okay. It's never about the money. I could give a rat's ass about the money. I don't care about the money. I'm going to waive all your fees. Okay? I don't care about the money. But what I care about is public safety. I'm now taking off around probably, $6,000 in fines and fees off you now, Mr. LaBoma.
Thank you, sir.
But if you pick up another DWI, if I see you pick up another DWI, from now on you're facing not only a minimum of 30 days in jail, but a second DWI, it's a $6,000 surcharge. Get a clue. It's not hard. Good luck.
Thank you.
Thank you. Just so you know, you're not here alone. Your lawyer is here with you on Zoom. Ma'am, you were placed on probation in this court in 2022. We've had many, many issues. Our first motion to adjudicate was filed, it appears, in November of 23. You were placed back on probation. It looks like a new motion has been filed in February for a variety of things. A warrant had been issued, and I guess now you're here with us. I just don't know how to go forward.
That's all.
Stop. Don't need you to.
Just listen,
right.
please. Don't say
Just
anything.
understand that, now that it's not time to fight the case. The only thing that we're dealing with now is a motion to revoke, the underlying issues, and what I see is that you're still testing for illegal drugs. I don't know how to go forward, but I don't want to set you up to failure, to set you up to fail as well. So what we do is we have something that's called a TRAS, where I have you evaluated by clinicians to see what is the best way to go forward, because I just don't know. The last thing I want to do is just start pleading people guilty here, left and right, and just end up with, conviction after, no. So the idea is that you leave better than you came. It still hasn't happened. So we need to find out how that's going to happen. So I'd like to please set up our TRAS. Your bond is set now at $10,004. So I have to take you into custody because of the warrant. So I will try to get it done as quick as possible. We could probably have the TRAS done. Do you think maybe tomorrow?
She'll probably still be in processing tomorrow, but by the end of the week.
Okay, we'll try to have it done by the end of the week. They will give us guidance on how to move forward, because I just don't know at this point. The only thing I'm going to tell you is please be honest, because if I get it and it says that there's no issues and it's rainbows and gumdrops, and I know it's not true, and we're going to do it right over again. Okay? Okay, so she goes with you. Okay, thank you, Mr. Bernie.
And Your Honor,
Yeah,
if possible, can we try to get the TRAS done by Thursday so she could be in court Friday? Because I'm out.
I will. I'm going to try. So the problem is though, is that what takes a lot of the time, Brock, is the processing. Because we're taking her in now, it's nearly 11 o'clock. They'll probably still be processing her early into tomorrow. If she's still in processing, they can't get it done. Maybe in the afternoon, tomorrow afternoon, they can get it done. I would say probably the latest, today's what, Tuesday? Maybe the latest is Thursday to try to get it done. And then we can try to get the results by Friday.
Okay.
And that's.
Put it on the
if
docket
everything
for Friday?
goes- Yeah,
Can we
hopefully.
put it on the docket for this Friday, Yana? Like I said, I'm out all next week. I don't want her to.
So because she's in processing, because she'll be processing now, she will auto-populate on tomorrow's docket.
Okay.
Then we can put her on for the Friday. So I
Sounds
can't
great.
really put her on for Friday yet because she'll auto-populate for tomorrow. But tomorrow, then I will put her on for Friday.
No problem. And can you consider reducing the bond somewhat, Your Honor?
No, this is our third case within the last two years. You know, we've had multiple MAJs. I mean, you know, she's doing what she wants to do, and that's it.
I understand, Your Honor.
Thanks, Brock.
No problem. I will see you Friday.
Okay, I'll reach
Have
out
a
to
good
you tomorrow because she'll pop on tomorrow's docket, so I'll reach out to you tomorrow regardless.
Yes, Your Honor.
Really? It's good? Fun?
No, it's really not, but I'm blessed to be alive.
Well, that's a good attitude to have. That really is, because it could be a lot worse. You could always be 6 feet under, right?
Right.
Your lawyer is asking me to set you a bond, but I'm really concerned. This case is very old, and you've been out, literally, she's been on the land for 10 years, Dave?
Well, the warrant was on November 9, 2015 for this one, Judge. But the surrender for the judgment roll was on, actually, the enrollment date was February 16th, but the surrender notice to file was April 2020. So I don't know what kind of efforts they went, but the actual forfeiture date was in 2015.
Do you know, do they really want, are they going to come?
Like with the other ones, I can only confirm the initial teletype confirming that the warrant is valid and they do still want her.
We've tried to reach out to, I'm sorry, Mr. Kim has tried to reach out to the demanding jurisdiction to see how serious of a case is it? Are they really going to come back? But he's been unable to reach anyone. And I mean, it's only been, 30, 45 minutes. So, your lawyer's asking me to set you a bond. Because of the nature of the case, the type of case it is, and because of the age of the case, you're asking for
Your Honor, the state's asking for $10,000 because it is a possession of controlled substance with intent for oxycodone and the fact that it's been in forfeiture status since 2015. This isn't one where it's a to-be warrant. It's one where she appeared in front of a judge, stated she would return, and then she didn't do that.
you want.
$1,500, Judge. My client has expressed to me that she is a college student. She has expressed to me that she only works for, because she's in school, Uber and DoorDash. She has expressed to me that she has an attorney that is working because she doesn't want this behind her. She can't have this when she graduates in May, if I'm not mistaken. I have explained to her the ramifications if this court was to give her the bond, that she has to that attorney either has to get her a date set there or she has to go turn herself in within the 14 days. She does not have any other criminal history or connection or contacts with police that were dismissed or otherwise, except for this one case from 2015.
The thing is that I have to set your bond sufficiently high so that you understand that we mean business. I'm not going to play this game with you again. If I set you a bond, it's only going to be one time. I won't do it again. You need to understand that there are serious consequences with the actions that you take now. I'm going to set you a bond. I'll set your bond at $5,000. And if and when you make bond, we give you 2 weeks from the date of your release to go turn yourself in to that jurisdiction where you're wanted from. Mr. Kim, where is it?
It's in Mississippi, Harrison County.
Go.
So you have to go turn yourself in. If you fail to do that, I will revoke this bond. I'm going to set it at 0. I will issue a nationwide warrant for your arrest. Obviously, I mean, you can't run forever, right? We're going to get you again, and this time I will physically hold you until Louisiana comes and gets you. Do you understand?
I do, Your Honor.
Okay.
So just knowing that, he has made the bond for $5,000, is that something that you or your family is able to post? Because if not,
$5,000 cash?
it's $5,000.
Oh no, I have a deaf baby. I'm a single parent. My husband died 3.5 years ago. I'm on a fixed income. That's why I do DoorDash, and that's why I do Uber on the side just to help,
So I said that to say that the waiver, if he sets the bond, then the waiver goes away. They don't come and get you. You don't get to have the bond and wait for them at the same time and see which one happens first. So if you're not going to be able to pay the money, then you can, the option is to leave the waiver that you have in place that you signed on, I think 2/27, and then let them see if they're going to come get you or not. But your time, you don't lose the time that you've already been in custody.
So when you buy, I'm confused, when you behind,
What day did she waive?
Right off that 227?
February 27th.
So you have 1, 2, 3, 4, 5, 6 days credit. We give them 14 days to come get you. If they don't come get you within the 14 days, we release you. They file a dismissal, I sign it, and then they let you go. If that happens, the warrant will always remain active, and that warrant will always remain active until you physically go back or somehow go back to Louisiana and take care of it. That said, if you want to make this bond, you have to withdraw that waiver that you have, and then you lose those 6 days. So if you withdraw it and you don't make the bond, you lose all that time, and you basically it's told until you re-waive or you make that bond.
I only say this because of the age of the case and the fact that I didn't know she had counsel in Mississippi. It's very, very rare, but I have been seeing it happen here and there, is if local counsel there can get a new setting date. Like I said, it's incredibly rare. I can count on one hand the amount of times it's happened.
What do you mean, get a new setting date?
So even if they don't appear with sufficient evidence, the Marsh Sheriff's Office says she's in our custody and her persons is here, and for a variety of factors, I can't speak to Mississippi because I'm not licensed there and I don't work there, is whatever sufficient factors they have to set a new date for her to self-surrender versus outside of the fugitive, they'll recall the warrant. So like I said, it's incredibly, incredibly rare, but only because of the age of the warrant and the fact that she has counsel there.
But we don't know that.
Well, but I'm saying if the information for that counsel can be sent to.
I mean, I'm not going to give you a PR bond. This case is 10 years old. You've been I need you to understand that we mean business. I'm not here to play games. And so that's why we have to set it sufficiently high so that you realize that you have to have skin in the game so that we know that you're going to go back. I'll let you guys talk about it. I don't want you to make a decision here in front of everybody. So you guys talk about it. You know, I'm not stuck on the 5,000. I go back down a little bit, but it's not going to be much, you know. But
I'll stand down. Thank you, Judge.
So,
Yeah.
So
Yes, sir.
I'll let you guys go talk.
Okay,
I
sir.
want you to say something here that you might invariably regret because it's in front of everyone, you know? Okay, please.
Thank you, Judge.
Thank you,
I'll
Judge.
go down some, you know, but a reasonable amount.
My face. Buckle up, guys. Today we are going to watch how a courtroom sets the tone in under 2 minutes. The judge wastes no time establishing authority, laying out the charge, the jail exposure, and the fines with surgical clarity. The officer's narrative is clean, methodical, and devastating: active warrants, an invalid license, no insurance. This isn't speculation, it's documented reality. When the defendant tries to interrupt, the judge shuts it down instantly, reminding her that this is not a casual conversation, it's a court of law. Even her appearance is addressed, signaling that accountability here goes beyond paperwork. The key moment is the bond condition: don't drive, period. No excuses, no life stories, no sympathy. The judge frames it bluntly: violate this, and jail is guaranteed. This opening works because it establishes the power dynamic immediately. The court controls the pace, the rules, and the consequences, and the defendant is clearly not steering this vehicle anymore. The focus shifts to a DWI plea, and the judge transforms into a legal reality narrator. Every condition of the agreement is spelled out slowly, almost relentlessly, as if daring the defendant to claim confusion later. Probation, classes, treatment, evaluations. This isn't a slap on the wrist, it's a structured overhaul of behavior. The most striking moment comes when the judge explains permanence. A DWI isn't just a conviction, it's a lifelong flag that follows you across states, across years, across every traffic stop. The courtroom gets quiet when the judge walks through a hypothetical future stop, explaining exactly how fast things can spiral if alcohol enters the picture again. This isn't fearmongering, it's probability. The judge makes it clear that by pleading guilty, the defendant is trading trial rights for certainty, and once that trade is made, there's no return policy. The gravity lands hard, and the defendant clearly understands the weight of the decision. Now the judge tightens the screws on compliance. License status, insurance, interlock requirements, every technical detail becomes a potential tripwire. The message is unmistakable. Paperwork mistakes turn into arrest warrants in this courtroom. The judge doesn't just warn about violations, he explains the mechanics of enforcement, including interstate consequences that can leave someone sitting in jail for weeks. Then comes the pivot. Despite the severity of the case, the judge weighs thousands in fines, making it crystal clear that money has never been the point. Public safety is the only currency that matters here. But that financial mercy is paired with a zero-tolerance future. Another DWI doesn't just mean more trouble, it means mandatory jail and massive penalties. This segment shows the balance of power. Leniency exists, but only inside strict boundaries. Step outside them, and the system snaps shut without hesitation. The courtroom tone darkens as a defendant with a long probation history steps forward. The judge isn't angry yet, he's disappointed, which is often worse. Repeated violations, failed drug tests, and prior chances have stacked up into a credibility problem. Instead of immediately revoking probation, the judge pauses and acknowledges a deeper issue. Punishment alone hasn't fixed anything. That's where the evaluation comes in, not as kindness, but as a last attempt to figure out whether rehabilitation is even possible. Still, accountability isn't postponed. An active warrant means custody today, no debate. The judge makes it clear he's trying to prevent failure, not enable it, but the patience here is running thin. This segment highlights the court's internal conflict, helps someone improve, or stop the cycle before it harms others. For now, the system chooses both restraint and control. This section is procedural on the surface, but the tension is real. Lawyers negotiate timelines, evaluations, and docket logistics while the defendant's freedom hangs in the balance. The judge explains how processing delays can derail even well-intended plans, underscoring how little control defendants actually have once custody begins. A request to reduce bond is denied without hesitation. This isn't stubbornness, it's pattern recognition. The judge references repeated cases and recurring behavior, signaling that past leniency didn't work. The message is subtle but firm: the court is done experimenting. What stands out here is how bureaucracy becomes consequence. Miss a window, miss a form, miss a deadline, and the system moves on without you. The judge isn't emotional, he's decisive. That decisiveness signals that future hearings will be about outcomes, not explanations. The final stretch is a masterclass in judicial leverage. A decade-old out-of-state warrant resurfaces, and suddenly time itself becomes part of the case. The judge listens to arguments about age, hardship, and intent, but he never loses sight of the core issue: this defendant promised to return once and didn't. That betrayal shapes everything. A $5,000 bond is set, not as punishment, but as proof of seriousness. The judge then carefully explains waivers, custody credits, extradition delays, and the uncomfortable truth that avoiding the problem doesn't make it disappear. Every option is laid out, along with its risks, so there's no room for later confusion. The judge's final move, stepping back to let private discussion happen, adds tension rather than relief. The decision still looms, unresolved. This ending works because it reminds everyone watching that the system doesn't forget, it waits. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.